Hey guys, and welcome to today's video. Today, we have two sovereign citizens who couldn't find a win in court even if the entire supply of breakfast crayons was on the line. We're starting in Michigan, where we meet a genius who thought it was a great idea to open credit cards in his own name, admit on the record that he used them, and then tell the judge there was no possible way for the creditors to get their money back. Yes, he's really that dumb. But before we begin, let me tell you about today's sponsor, Extra. Extra is one of my favorite brands to work with, not just because they make great products like their smart card holders and vacuum travel bags, but because I've personally been using my Extra wallet for over 3 years. And when I need a gift for the people who actually matter to me, Extra is always my go-to. The wallets hold more than enough cards for the average person, but the best feature is the quick release button. It lets me access my cards instantly. Perfect for hotel rooms. I just press the button, and the cards pop right out. No fumbling, no forgetting my room key when I leave. If I have my Extra wallet, I've got my room card, my ID, and my credit cards, all in one place. Since partnering with Extra, they've also added new products like these vacuum travel bags, which let me pack enough clothes to last for months without constantly buying or giving away clothes in every city I visit. In fact, I'm leaving for Turkey tomorrow, so let me show you how they work. You simply load the bag with clothes, attach the USB-C rechargeable vacuum pump, and watch it shrink down in size, letting me fit everything I need into a carry-on that easily fits in the overhead bin on most airlines. So head over to partnerextra.com/teamcoepic to save up to 54% during their holiday sale. And use code SKEPTIC at checkout for an additional discount on your order. And thank you once again to Extra for sponsoring today's video. Now, let's begin.
All right, we are on the record. First matter is Amex versus Jason Campbell Everett, case number 243818GC. Is counsel here for the plaintiff?
Yes, Your Honor. Dreek Gertzberg, P80136, appearing on behalf of Plaintiff American Express.
Good morning. And sir, you are Jason Everett?
Yes, sir. I'm here on special appearance. I am
What?
the registered agent for the registered.
I'm sorry, you're not Jason Everett?
Yes, I am Jason Everett on special appearance.
All right. So, Ms. Gertzberg, this is a claim of failure to pay a credit card debt.
That is correct, Your Honor.
And I've read the answer that you filed, Mr. Everett, and you deny that there's a contract and claim that there's a statute of frauds problem on the plaintiff's complaint. Is that right?
That's correct.
Okay. All right. So we're going to allow discovery, which is a process in a civil lawsuit where each side can request documentation from the other side with regard to their claim. I'm going to allow written discovery only. And discovery will be open for 90 days. So that will take us to February 6th of 2025.
Your Honor,
Yes.
as attached to the defendant's answer were a number of what appeared to be discovery requests, a number of written requests for, I guess I would say, similar to interrogatories and requests for productions of documents, but
Okay, well then I
they
guess
were,
I would suggest that your client should answer them.
well, they were not presented in the appropriate manner. They are not in conformity with the
Well, counsel, you
the
can
court
either
rules.
have your client answer them or you can file an objection.
Sometimes I wonder whether interrogatories filed on saliva-stained glass panes constitute a valid objection.
And then the court will take them up. The purpose of discovery is to to allow each side to discover what the other side's claim is. And so if your objections are just going to be based on form only, I'm probably not going to be terribly concerned about the form, particularly where the defendant is unrepresented in the case. If there are some substantive issues, then you'll need to brief the issues and bring them before the court with the proper motion. So witnesses need to be exchanged by February 6th of 2025. Exhibits need to be exchanged by February 6th, 2025. And motions may be filed and heard as permitted by the court rules. We will set this matter for a non-jury trial. That'll be a Friday. We'll need some date after March, or in March or later.
March 14th,
March 14th
9:30.
at 9:30, and that'll be in person here at the courthouse.
I just can't have my client have to respond
Hang on
to
just a
50
second, counsel.
interrogatories.
Just a second, counsel.
March 14th.
I'm sorry, counsel, did you have something you wanted to say to the court?
I can't, in good faith, have my client answer 50 interrogatories.
Well, I guess, counsel, I think I've tried to direct you as to what your ability to respond to those are. So I'm not going to practice law for you, Ms. Gertzberg. You'll need to do it for yourself. So we will schedule the matter for a non-jury trial in person, March 14th at 9:30. And is there anything else for the plaintiff?
No, Your Honor, thank you.
Okay, anything else for the defense?
Judge, I'm just curious on why this counsel is here when I have another counsel on my paperwork.
Okay, Ms. Gertzberg, can you explain your involvement in this case?
We work at the same firm. The appearance of counsel of one member of a firm is the appearance of all members of the firm.
Okay, all right. So I think that that
Fair
is
enough.
pretty common response, and I think that is acceptable. So
Fair enough, yes.
okay, all right then. That's all for the record today, and we'll send a copy of this pretrial order to both parties. Thank you.
Thanks, Judge.
Thank you, Your
Welcome.
Honor.
So, that wraps up the first hearing. They did return a few months later, and the outcome was entirely predictable.
All right, next matter is American Express versus Jason Everett, case number 243818GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Andrew Tetro for plaintiff.
Good morning. And sir, you are Jason Everett?
Yes, sir, I'm here on special appearance and I reserve all my rights under UCC 1308.
Okay, good morning.
Good morning.
All right, this is plaintiff's motion for summary disposition. Mr. Tetro, you may proceed.
Thank you, Your Honor. Yeah, this is plaintiff's motion for summary disposition. It's being brought pursuant to MCR 2.116 C9 and C10. C9 is failure to state a valid defense, and C10 is no genuine issue as to any material fact. Excuse me. The evidence that's offered in support of plaintiff's motion establishes that Mr. Everett opened a credit account with plaintiff in November 2016. He used his card to make numerous purchases over the next few years. He accrued a balance which went unpaid. The account went into default, and now the plaintiff brings this count of breach of contract to recover the unpaid balance on the account.
Okay. There was a response filed to the motion by Mr. Everett. Did you receive the response?
I don't believe so.
Mr. Everett, did you file the response with the plaintiff's counsel?
Yes, sir, I have tracking number. I can track it.
I'm sorry, you have what?
I have a tracking number for the mailing. I can track it.
This was filed back on March 24th. Is that right?
Yes, it was sent out the same day, USPS.
What's the title of the document?
Notice of judgment to dismiss for lack of contract and jurisdiction.
It's notice of motion to dismiss for lack of contract and jurisdiction.
Okay. Does it also say high priority judicial declaration?
Yes, it does.
Okay, we did receive that.
Okay. Would you like to respond to it?
Yeah. So the filing that Mr. Everett has filed, now it's my understanding that this is a response to the motion for summary disposition. It doesn't really address too much of what's in the actual motion for summary disposition. It does talk a lot about the UCC and Fair Debt Collections Practices Act. Most of what the plaintiff talks about, or excuse me, most of what the defendant talks about in his response is not applicable to this case. UCC doesn't apply to consumer debt. The Fair Debt Collections Practice Act doesn't apply to the originators of the debt. Yeah, most of it's not addressed to the motion. So, and also it doesn't offer any affirmative or documentary evidence to contradict that which is offered in support of plaintiff's motion. So I think at least as it stands for the C10 aspect of the motion, no counter evidence has been offered. He hasn't created a genuine issue of material fact.
You're kidding, right? You mean all of that paperwork he filed is exactly what it looks like, pure nonsense. Now, the defendant does have a response, and some of you may have noticed I didn't say a valid response. That was intentional.
So one of the things argued by Mr. Everett is that there is no contract, and what is your position with regard to the existence of a contract? You said this is a breach of contract complaint.
Yep, there's a contract. There was a contract attached to the complaint that was filed. There's a contract attached to this motion.
Those were signed by both parties?
I don't believe they were signed by any party, but there's no requirement for a signed writing. Statute of fraud doesn't apply to credit accounts. The terms of the agreement that are attached to both the complaint and the motion are clear, and the terms of which are clear and unambiguous, that use of the account is acceptance of all the terms of the agreement.
Okay. I'm just looking at for the complaint in this manner. It's strictly a breach of contract complaint. Is that right?
Yes.
Okay. It's not an open account claim.
No, I don't believe so. I think it was just one count for breach of contract.
Okay, Mr. Everett, response?
I wholly disagree based on all of my research and based on all of the listings from UCC, listings from the Internal Revenue Code, subsection 166 on charge-off reporting. My Exhibit A was proof that the account was charged off. That basically prevents financial institutions from profiting from a debt that was already satisfied through other means, which means if it was charged off, they got a tax credit for it. I also listed in here that if they cannot enforce if they've already received benefit. That's just one of many here, sir, that are legitimate and are applicable to consumer accounts and consumer law. Statute of limitation, statute of frauds, UCC 2201 requires that a contract for the sale of goods for the price of more than $500 be in writing and signed by the party whom enforcement is sought. They have no signatures. They have no electronic signatures. They have no wet signatures. There's quite a bit of things here, sir, that are not aligning with what the plaintiff is claiming.
Well, let me ask you this. I mean, you did have a credit card that was from American Express. Is that right?
Yes, sir.
And looks like you used that credit card for charges at numerous local locations, including Granger Waste Services, Meyer, Capital City Grower Supply, Chipotle. And they haven't been paid for those charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I have reserved my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. And I do not accept the liability associated with the compelled benefit of any unrevealed contract or commercial agreement, whether it be adhesion or hidden.
Okay. So you used a credit card and charged it up and didn't pay it off. I mean, that's really what the facts are here in the case. I
They don't
see
have
it.
any mechanism for enforcement, sir.
That's a bold move, admitting you received the credit card, used it for everything from food to grow house supplies, and then claiming you don't have to pay it back because there's no way to collect the debt, all while actively participating in the very system used to collect it.
Okay. All right. Anything further, Mr. Tetro?
Nothing further other than just to reiterate the fact that he would have been provided with a copy of the agreement when the account was opened. It makes clear that use of the account binds him to the terms of the agreement. He's just admitted that he used the account. So I think the facts are kind of undisputed at this point.
Okay. Well, I do not find that there is a genuine issue of material fact. I find that the defendant did use his American Express card, did run up charges and receive a material benefit by using it, and that obviously he made some payments on the account, which acknowledged that there was an agreement that if he used it, he would pay, and then he stopped paying at a certain point in time and went into default. The court does find that his use of the credit card and acceptance of the benefit of using that credit card to make purchases does constitute a binding agreement, and therefore I do find that plaintiff is entitled to summary disposition of this claim. The various laws that were cited by Mr. Everett are not applicable. And so that's the ruling of the court. I will sign an order. Was there an order, a judgment submitted, Mr. Tetro, with the?
Yes, Your Honor. If you have the motion packet, it should be the very last 2 pages of that whole motion packet. The last 2 pages of the exhibit should be a proposed order, or excuse me, proposed judgment.
It's about a 300-page motion packet, so it's a little bit difficult to.
Should be the very last page.
Okay. Okay. All right. That's all for the record in this matter. I'll sign the order and send it to the parties.
Thank you, Judge.
Welcome.
Well, that's the end of his first case, and, no surprise, he takes his first loss. But that's not the end of it, because another case followed immediately, and he did the exact same thing. So let's watch him take loss number 2.
Next matter is Bank of America versus Jason Everett, case number 243844GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
I'm well, thank you. Good morning, and good morning again, Mr. Everett.
Yes, sir.
Okay, this is plaintiff's motion for summary disposition. Mr. Kirschenheiter, would you like to, did you receive the response filed by Mr. Everett in this matter?
I did, Your Honor. It's titled motion to dismiss, same as the previous case, but we did receive it, yes.
Okay. All right. What would you like to tell the court?
Judge, it's pretty straightforward. It's a credit card claim. It's an account stated claim. it's a C9, C10 motion. We don't believe there's a genuine issue of fact. There's been no valid defenses pled. Defendant opened up this credit card. He used the credit card. Statements were sent to the address that he lists as his address. He made payments on the account. There's a balance due and owing. We've provided those statements showing the use of the account, as well as an affidavit as the amount due and owing. Pursuant to C9, only the pleadings may be looked at, and defendants did not technically file an answer. He filed an affidavit under the UCC, does not deny any of the allegations in the complaint. There's no affirmative defenses that have been pled. Under C10, we don't believe there's a genuine issue of material fact. We believe we've got the burden with our pleadings. So we would ask that our motion be granted and judgment enter.
Okay, thank you. Mr. Everett, your response?
Yes, sir. Again, no material contract, no informant consent, no signature, no social security number listed. I reserve my rights to be compelled to exercise any compelled benefits that were hidden from me at its initiation. Same as before, sir. I don't believe they have standing for claim.
Okay. All right. Well, the court has reviewed both the motion and the response, and it's very clear based on the exhibits attached to the plaintiff's motion that that Mr. Everett did have a Bank of America card and did utilize it for multiple purchases, many of the same locations that were indicated in the previous case, including Meyer here in the Mason area. See, the consumer's energy bill was paid or was charged to it. And so clearly Mr. Everett received multiple benefits by using the card. He did make some payments under the cardholder agreement, and at a certain point in time defaulted and stopped making payments. I do find that there is no genuine issue of material fact. I do find that the plaintiff is entitled to a judgment as a matter of law, and I will enter a judgment granting summary disposition for the plaintiff. Mr. Kirschenheiter, was there a judgment submitted with the
No, Judge. I will provide an order to the court.
Okay, you may submit that under the 7-day rule.
Will do.
Okay. All right, that's all for the record, gentlemen. Thank you.
Thanks, Judge. Have a great day.
You as well. Thank you.
If this sovereign citizen is consistent at anything, it's taking losses. Next up, we have another sovereign citizen, this one caught trying to sell large quantities of illegal narcotics, who claims the court has no jurisdiction despite being locked up and facing years in prison.
Deputy, if you would also inform Ms. Bender there's a no contact order with her co-defendant, Mr. Burns.
I will do that, sir.
Thank you. All right, are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got on this paper charged with all cap letters.
Are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got charged on this paper with all capital letters.
All right, I can't understand what he's saying, Deputy Malone. Can you repeat it?
I am the living man, Christopher Burns, not the entity you got charged with all cap letters on this paper.
Okay. Well, obviously you're living or you wouldn't be there. Just answer the question if you are, and you are Mr. Burns. So, Mr. Burns, you were indicted by the grand jury yesterday on a number of charges. First 4 counts, I'm sorry, just on 2 counts, I'm sorry. The fifth and 6th counts. And count 5 alleges that on or about June the 29th, 2024 in this county, you knowingly sold or offered to sell methamphetamine, a Schedule II controlled substance, in amount over bulk less than 5 times bulk. And then count 6 alleges that on about the same date, you possess that amount. Now, each of those are third-degree felonies which, if convicted, carry a possible prison term between 9 and 36 months and a fine of $10,000 and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. And I see you filled out a financial statement. Is everything on this financial statement correct?
Yeah.
All right. When's the last time you were employed, Mr. Burns?
I don't know. I like to see the official criminal complaint against me, and I like to plead the fifth. I ain't got nothing else to say.
Well, thanks for that. I'm sure everyone really appreciated you saying absolutely nothing, especially when you can barely speak understandable English to begin with.
All right. Court will find that you are entitled to appointed counsel. I'll appoint Attorney Dennis Kirk to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf.
I don't want to enter no plea. I like to see the official criminal complaint against me first.
Well, you're going to need to talk to an attorney first. I'm not in a position to do anything today until I hear from everybody involved in the case on both sides. So, in the absence of counsel, the court enters a not guilty plea on your behalf. I'll set a bond.
I don't want it.
Don't interrupt me, Mr. Burns. I'm going to set a bail review hearing by Zoom tomorrow at 8:30. There'll be a final, a first pretrial on your case on October the 17th at 1:00 p.m. There'll be a final pretrial on November the 20th at 1:00 p.m. And then the trial will be set for December the 19th at 8 a.m. Bond will be set in your case for at $5,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay service fee deposit of $171 prior to release to cover the statutorily required fees. If you make bond, you'll be under pretrial supervision of probation department, 117 East Main Street. Be required to report to them as soon as you're released. Then once a week for 4 weeks after that, as they determine, undergo random drug testing in my order, provide phone numbers for home, cell, and employer. Recommended by probation, will be evaluated for substance abuse or mental health issues. If there's any treatment indicated, you enroll in and file that during the pendency of this action. You'll be under house arrest at your residence at 236 East Beach Street in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any case. You can attend any kind of educational programming, classes, etc., church services, and holiday family events. And also, you're not to have any contact with your co-defendant, Joey Pender. All right, we'll notify your attorney of his appointment. We'll have your hearing. If you don't make bond, we'll have your hearing in the morning. If you make bond, there won't be a hearing. Do you have any questions, Mr. Burns?
No.
All right, thank you.
Well, that wraps up his first hearing. And if there's one takeaway here, it's that this man has somehow made it through life without a functioning cognitive organ. He did eventually bond himself out, but that won't last long. His refusal to participate in his own trial is practically guaranteeing that the judge sends him right back into custody.